The webinar is going to be focused on California breaks. I'll start by introducing myself and Charles. I am the Chief Revenue Officer here at BusyBusy, so manage everything, sales, marketing, client success, and all of that. And then Charles Hart, who is going to be the primary person speaking here on the webinar, is our product manager. So for those of you not familiar with software, product manager is a very technical position. Charles spends a lot of time researching before product is developed to make sure that the product is developed in a way that's best for our customers. And why you would care about that is because he spent a lot of time researching California breaks. It's a part of a product that we built, and for us to be able to build it and get it right, Charles had to make a very deep dive into California breaks, understanding what they are, what the regulations are around them, and how the best ways we could help clients be compliant with California breaks. Couple things to note as far as the webinar itself. We do have some slides that we'll be sharing throughout the webinar. I want to make sure everybody knows that if you see things on the slides that you're writing down to take notes, don't worry about that. We will send you the slide deck after the webinar, so you will have access to that slide deck. And then we also will be, this is being recorded and we'll be posting it on YouTube, and then we'll also send everybody a YouTube link. So if you've got other coworkers, or if you're an office administrator and you want to show it to the owner, or if you're an owner and you want to show it to your office administrator, you will have access to the recording and the slide deck. So no problems there. As far as the webinar itself, a couple things that we're really going to focus on. We want to clarify the technicalities around meal breaks and time rounding and how that affects California breaks as a whole. There are 3 very prominent court cases that have taken place in California about California break policies. And so we're going to do a deep dive into those court cases and talk about the rulings in those court cases, because of course with court cases, once a court case has a ruling, that's used as a precedence on other rulings in the future. So understanding how to navigate how those outcomes would affect your business would be something that we want to focus on. There is a chat feature at the bottom. So if anybody has questions at the end of the webinar, we will do a quick Q&A and we'll get to as many questions as we can. So if anybody has questions throughout the webinar, please, as they come up, feel free to write that information down in the chat, submit it over, and I will review those questions and we'll get to as many as we can based on the time frame that we have. And then lastly, I just want to make sure that everybody attending the webinar and everybody who watches this on YouTube is aware we are not attorneys. This is something that we're here not as lawyers giving specific legal advice. We're here to help customers understand the parameters of how California breaks work and help people understand where they can find some information that they can then talk to their attorney and make final decisions on how they want to navigate California break laws for their company to navigate liability and be as compliant as possible. So having said all that, I'll turn the time over to Charles and we'll learn about California breaks and hope to help your businesses. Thanks for attending.
Yeah, thanks, Derek. Okay, so to get started, California breaks is part of it's part of the labor laws that are required for California companies to follow, and these date back a long time. They date back all the way to as early as 1916, 1932. There's been a focus on helping employees have safe working conditions, and they've evolved over the time, and the ways that the laws have been written have changed over the time, and then the ways they've been interpreted have also changed. So let's, to start with, go with a brief overview of where they currently are today, what the requirements are for a California break. When we'll start with meal breaks. So these are unpaid breaks that are required for employees to have. And if an employee has worked from 0 to 5 hours, they are not required to have a meal break. But between 5 hours and 10 hours, then there's a 1 meal break. And this table breaks down that throughout the day, if they work more than 10 hours, then there's two breaks or 3 breaks. And these are meal breaks that need to be given to employees. Going into detail on these meal breaks, to clarify what they mean, The law is pretty strict about these meal breaks needing to have the employee be completely free to be able to do whatever they'd like to be doing during that meal break. Unless the employee is relieved of all duty during his or her 30-minute meal period, the meal period shall be considered an on-duty meal. Now, on-duty meal is something that you can qualify to have employees be able to do on-duty meals. An example of this would be like if you have a security guard that needs to continue to offer security, and they do that during their meal, and those are considered paid meals. So you can have arrangements where you can qualify for on-duty meals, but there's a couple of things you should be aware of with these. One is that if you don't have your on-duty meals set up properly, then being classified as an on-duty meal actually just means that you need to pay the penalty that you didn't get the employees the break that they needed. In order to qualify for an on-duty meal, there's a couple of requirements. You need to have a written legal agreement between the employee and the employer that the employee will be able to eat and have their meal while at work. And in that writing, there's specific requirements that employee can terminate that agreement at any time. Most of the construction companies probably won't be getting this on-duty meal. The nature of the actual work has to be such that you would be granted that exception. So even if you have like a written agreement in place with an employee, it's not enough. The nature of the work has to be where the employee couldn't be relieved. So like the example of the security guard, if they just walked away, then the place wouldn't be secure, or like a kiosk worker or a manager that's working the night shift at a store. These are some of the like examples that is in the rulings as far as what the on-duty meal would be. So relieving your employees of all duty, that means it's pretty, like I said, expansive. Like you can't require them to be taking phone calls or to be on call. You can't require them to really do anything without violating that and being designated as, no, that was an on-duty meal and you don't qualify for the on-duty meal, so you're going to be subject to the requirements of what happens when you violate one of these meal break rules. So the meal break also is clarified in the rulings that it should be a meal period of not less than 30 minutes. And that's important, and we'll get back to that when we go into some of the court cases, but it has to be 30 minutes and not a minute less. Anything less than a 30-minute, like a 29-minute break, is considered as though the employee did not get their meal break. So it's very strict, and it's been interpreted very strict. For employees, if they've worked less than 6 hours, they can waive that first meal. If you remember, it was a 0 to 5 hours is the first meal, but an employee can waive that meal break for that 6th hour. And that was kind of carved out for employees in the food industry, that the 6th hour lined up with when they were busy and the employees wanted to work. And so there was an exception kind of carved out that, yeah, if you're working 6 hours, you can not take that, but you have to waive that as an employee. You can't waive that as the employer and just say, oh, we waived all the breaks because they were less than 6 hours. It has to be the employee that's waiving those. If the employer requires the employee to remain at work, which you can do, you are allowed to require your employees to stay at work, but if you do, they must be paid. So the meal period must be a paid period. And that's another thing that sometimes you'll see is employers don't want their employees to be leaving, but if they have that as a requirement, then they will be required to pay those employees while they're doing their meal period at work. The other kind of break is the rest breaks. And these breaks are 10-minute breaks that occur throughout the day. And the times that these are ideally supposed to lay out is to fall between the meal shifts, so that it's kind of as far away from the meal shift and the start of the shift as possible. But that's not required. You can be fuzzy in when those breaks occur. They can be earlier or later than that kind of midway point. But 0 to 3.5 hours, no meal, or this should say rest break right here. No rest breaks for 0 to 3.5 hours. 3.5 to 6 hours, one rest break, and you see the table on down for each one. These rest breaks are also clarified in a couple ways. For construction in particular, this first one's kind of important, where those breaks can be staggered. You may stagger the rest breaks to avoid interruption in the flow of work and to maintain continuous operations. So you could have some employees take their rest breaks, and then some other employees take their rest breaks, and they don't have to all happen at once, and they don't have to be right at that kind of 3.5 hour mark. They could be kind of fuzzy there because you might have operations that need somebody to be doing something in the moment to work together and collaborate. And construction is specifically called out with that flexibility in mind in the rulings. The on-call rest periods, those are not prohibited. So you can't be on call during your rest period either. Can't be required to be available on the phone or whatever. The ruling similar to the mill, where if you are making those requirements, then those employees are not free to be doing whatever they want there. So they are required, they can't be required to be doing anything for work. I said 10 minutes, but it's actually a net 10 minutes, which means that the rest period begins when the employee reaches in an area away from the work area so that is appropriate for rest. And that means that it's a little bit subjective, but that basically means you can't start someone's break when they're in their equipment operating some machinery, and as soon as they step out, their break starts and they've got to walk over to where like the restrooms are and some of the other places they could take a break for 10 minutes, whether it's a smoking break or a lactation break if you have breastfeeding needs. Those breaks don't start until after, they call them the net 10 minutes. The requirement to relieve employees of all work duties and employer control during that 10-minute rest period. Again, it's pretty strictly interpreted there where you can't require those things. Another careful thing you want to be aware of is that a lot of employers try to say like, well, you can't go to the bathroom because you already took your break. You want to avoid that. They specifically prohibit an employer from requiring that employees count any separate use of toilet facilities as a rest period. So employees can go use the restroom during the rest periods, but if they need to use the bathroom again or another time, you don't want to deny them that access. It won't be looked at favorably.
Hey, Charles, a couple questions. I know we were going to do questions at the end, but these are all completely contextual to mill breaks. So I'd like to jump in here while we're on the topic if we can. A couple really good questions. One, Jeff asks if smoke breaks count as rest breaks. I know you clarified bathroom breaks don't, so if you could speak to that, or did you see anything there where?
Yeah, so smoke breaks, you can use your rest breaks for smoking breaks, but you don't have to give employees additional breaks for smoking. So just because an employee does smoke and wants more breaks than the number of breaks, they do not get special additional breaks because of a smoking need.
Okay, and then another question from Martin is taking a meal break on site but in a work truck considered a paid or off-site non-paid meal break?
So the meal breaks would be unpaid unless you're requiring the employees to stay on site in their truck. If you're requiring their location to be a certain location, then those should be paid.
So ultimately anybody can eat on site whenever they want, as long as it's not a requirement.
Yeah, for sure. As long as the employee is choosing to eat on site, maybe they don't want to leave and then come back, or they bring their own lunch. In construction, oftentimes you're remote site. And that's actually a good segue into a point I should make is that a lot of industries are required to have a designated meal period place, like a rec room or a place where you would have access to hot water and the ability to heat food and store things. That's not the case for construction. There's an exception for that where construction can have their employees eat on the job site or not provide those if they're in a remote location where it doesn't make sense to have kind of a rec room.
Okay, and then one other really good meal break question, and it's been asked twice already. Jeff, actually both of them are named Jeff, so I'll read both and then you can, it sounds like the same question to me. If travel time from home takes 10 plus hours of work, are they due a second meal break? And then a similar question is, does paid drive time, commute time, count toward the hours worked toward meal calculation purposes? For example, if I drive 4 hours to a job site and am paid drive time for all 4 hours, and then I work 2 hours at the job, am I required to take a meal break before my 6th hour of work?
Yeah, that's a good question. I would probably say at first, just for that answer to that question, I would probably for sure consult an employment lawyer. But I would say that my sense is that if you are on the clock for that drive time, so if employees are being paid for that time, that shift time, that's the time that would be used. As far as one of the rulings talked about continuous 5 hours of employment or time, and so that would probably fall under that, where if you're being paid for the drive time and then you are working, it's based off of the total hours that you're going to be paying for payroll is what they're going to be using for the calculations of whether you've received the breaks. Is they're going to be taking those hours paid, looking at the hours with the breaks and saying, okay, well, they didn't get those breaks. But I didn't see anything specific like excluding commute times. If they're off the clock, they wouldn't be counted. I'm pretty sure if you're not paying for that drive time and it's the employees are commuting there, then it wouldn't count towards that time.
Right. And I think it's a good clarification point that a lot of it is it's the way that it would be read in an audit. And so when you're looking at a payroll audit and you just see these hours that are paid and there's not a break in those hours, that would be pretty hard to explain. So, but there's someone asked can the first rest break at the beginning of the meal break, can the first rest break be at the beginning of a meal break, giving the employees a total of 40 minutes with 10 minutes paid and 30 minutes unpaid, all for the meal break? Is that acceptable? Yeah,
so I would caution against some of that. So they talk about the breaks, using breaks to like leave early. Like if someone wanted to do their meal break at the very end of their shift, that's frowned upon as far as having an excuse to leave early. That's the way they interpret that, is you didn't actually get your meal break. You just got sent home early. And it's similar with the rest breaks where you can't, or they would not look kindly upon like combining all of your rest breaks and leaving early, or taking all of those rest breaks with the meal period would be something you'd be taking a bit of a risk with. And so I do know with the rest breaks, it's a lot more flexible in that having like documented start and end times for rest breaks isn't a thing, because those are paid, you're paying for those. And so typically those aren't like stopwatch timed. So there's a lot more flexibility in terms of like how those rest breaks work. And the Department of Labor seems to want to work with companies that are trying to get their job done and have those rest breaks. But I would guess like bundling those all together would be frowned upon.
Okay. There's some other really good questions, but we'll get to them at the end because I want to make sure that you're able to continue to move through the rest of this.
Yep. Thank you. Good questions. So why are these break rules important to follow? I would say just first, before we get into any sort of like penalties or anything, having your employees be able to take the breaks that they're legally entitled to. And oftentimes they understand that if you have a good culture, there's all the advantages of having a good culture where employees feel valued and feel trusted, and employers don't feel like they're getting taken advantage of. So having good break policies in place is a good thing for company culture. But it's also important because of this, which this is the designation of what happens if you do not pay your meal breaks or your rest breaks. 1 hour of pay at the end, or at the employee's regular rate of compensation for each workday that the meal period was not provided. And 1 hour of pay at the employee's regular rate of compensation for each workday that the rest period is not provided. Now, a couple clarifications here. This rest period, that violation of that 1 hour, if an employee didn't get their rest break multiple times in the same day, they don't get 1 hour for each one of those violations. That's a little bit different when it comes to lactation. There was a case where the lactation was looked at as each one of the individual infractions was considered a violation, but generally the ruling is that those rest breaks at that 1 hour of pay at the employee's regular rate of compensation is just for one infraction per day. These payments can add up pretty quickly. So it's why you want to be aware of the way that this is going to come down. And it's also important to know that this is how you resolve the problem, but it's also not all of the problem. Like, you can also be hit with penalties, attorney fees, and various other fines in accordance with violating labor laws. It's not just this, but you're looking at this at a minimum as far as the way that this is going to be totaled against you. And that kind of takes us into our first court case, which is the Murphy versus Kenneth Cole Productions, 2007. This ruling was a store manager who got into a labor dispute with the Kenneth Cole Productions, and the question came up of, okay, well, we need to clarify what is that additional hour of pay, and does that constitute wages? And so that's important because a penalty in California, if you have a penalty, generally has a statute of limitations of 1 year. Whereas wages, if you have unpaid wages, those go up to 3 years. So in this court here, in this ruling, the judge ruled that those were wages, and that extra hour of wages was wages, even though it's like a 30 minutes, but the penalty is that 1 hour. That 1 hour of pay counts as wages, and that is retroactive for up to 3 years. So as a company, if there's a dispute where this comes down, that will be back paid up to 3 years from the time the employee files for the when they file their claim. That can go backwards in 3 years. So 3 years of each employee per day. And that also brings the question of, like, well, is this going to be all your employees or just one of your employees? And then that's separate in different cases. There's been examples where companies have had violations of their breaks that they were violating for all of their employees. And there's been ones that were just a single employee. But in cases where it's all of your employees, you could be liable for payments of each employee an hour of wage per day for 3 years, backdated. So it can add up really quickly, and then you're owed that, and that can be a lot of money that you need all at once. Now, the way that you would resolve if an employee said, hey, I didn't get my breaks, you can resolve them at that time by documenting that you are paying them that 1 extra hour, and that counts as the resolution. Like, that's how you resolve it, is you pay them that 1 extra hour for that missed day of breaks, and if them not getting their breaks. That additional hour of pay isn't included in overtime calculations. So that was that's also been determined. And so when they go backwards and they're like, okay, well, now you owe these hours, you don't have to then recalculate your overtime during those periods that you were penalized for. The next court ruling I want to mention is the Brinker Restaurant Court versus Superior Court. This is Brinker restaurant. You might not recognize that name, but like they own Chili's or Romano's or a bunch of other restaurants. And this one was in 2012. And this one kind of went more in the employer's favor in terms of the way that it was ruled. But the core important thing to understand from this one is that an employer's obligation is to relieve its employees of all duty during meal periods, leaving the employees thereafter at liberty to use the period for whatever purpose they desire, but an employee need not ensure that no work is done. In this court case, some of the restaurant employees were working during their breaks, and Brinker had in their policy that the employees weren't allowed to work during their breaks, and the employees were choosing to work during their breaks in order to either get tips or during different parts of the day when they were supposed to be taking their breaks. And so the court ruled that that it's not the employer's responsibility to force the employee to be doing a specific activity during that break. As long as they're not requiring them to do an activity, then it's not on the employer to have the employee forced to take what the employer determines as a break. Now, you do want to be careful with this ruling, because what you don't want to do with interpreting this is that if you know that employees are working during your breaks, when they're off the clock and they're working, you don't want that. So you aren't required to be controlling the behavior of all the employees during their breaks, but you don't want to know about them working during breaks and not be telling them, hey, you're not supposed to be working during breaks or anything like that, because that can also get you in trouble if you do know. Now, in Brinker's case, they had in their handbook that the employees shouldn't be working during their breaks, and in this case, this court ruling had a lot of different aspects to it, but at least in the case of was Brinker liable for this part of it, the court ruled in favor of Brinker and saying that no, you can't control what the employees are doing during those breaks. Okay, the next one we're going to go over, this one's more recent. So this is 2021. So this year, Donahue versus AMN Services. In this ruling, AMN Services was a nurses group. They had nurses, and the way that they were using some software that would track their time, and their time was rounded, which time rounding in California is allowed, and I'll clarify what I mean by that in a moment. But years back, there was a court hearing where there was some studies that were provisioned by the court in terms of determining whether time rounding hurt or helped employees, and it ended up being that employees were being overcompensated because of time rounding. So at that time, the courts were like, yeah, we're okay with companies having time rounding because employees, on the whole of it, get more compensation than they would otherwise. But what was happening with this Donahue versus AMN Services was that the employees would take their breaks, and their breaks were rounded. And remember, I pointed out that very carefully worded, not a minute less than 30 minutes. And so that not a minute less than 30 minutes is a big deal for the breaks, because those breaks were being rounded. And so when those breaks were rounded, there were times when the software that the nurses were using was not asking them, hey, you didn't get your breaks. What happened? It just wouldn't ask them at all. So they weren't even like documenting, hey, I didn't get my breaks or anything. There were just a lot of these cases where the software was allowing them to go fine because the time rounding. And the judge in this was pretty strictly against time rounding with regards to the breaks. And so there's a couple kind of quotes there. Well, first of all, just if time records show evidence of non-compliant meal periods, the court will assume a violation was committed unless the employer proves otherwise. Now, in this case, AMN Services was able to go through and show all of the times when the time wasn't rounded, that there wasn't a violation, and that helped protect themselves some. But in all the cases where there was rounding, the rounding was not favorable, it didn't go well for them. Even a minor infringement of the meal period triggers the premium pay obligation. So you gave your employee 29 minutes, you didn't give them the full 30, you have to pay for that full hour of the premium pay. It's not about like how much time was, it's just you didn't give them the actual break. The California Supreme Court declared that compliance with the 30-minute meal period must be based on a precise actual time with no time rounding permitted. And that's the one that's kind of the big kicker against time rounding systems. The meal period provisions are designed to prevent even minor infringements on the meal period requirements, and time rounding is incompatible with that objective. One of the things they showed in that court was that from a percentage wise, time rounding could be pretty significant towards that break. So if you just kind of got bad time rounding, a break could be quite a bit less than that 30 minutes. Like it could go down to like 22 minutes is all you were given, or depending on your rounding interval. And then what percentage of the break that was is substantial, where you missed out on 30% of your break or whatever. And so the judge was pretty strong against time rounding with regards to the nurse, this particular case. And I would say there's a couple things about this case that got them in particular trouble. One was that they didn't ask the question of like, did you get your breaks every day? They only asked it when the software determined that they hadn't been given their amount of break time. And then the other thing that kind of was a problem was that the totals that were presented to the employees for their breaks was also a time rounded total. One kind of other freebie that I don't have a slide for here, but one other thing to mention with regards to software, and when you're using software, auto deducting breaks, it's not a good idea. So auto deducting breaks was also, there was a court hearing in 2017 where a company, TE Networking, had to pay fines of $4.5 million because they had for a decade been just auto deducting 30 minutes from their employees' time. You don't want software that just auto deducts the time from the employees. The courts haven't looked good upon that either. And I'll point that out in a minute as well. So this kind of new interpretation of this time rounding, it just causes me to encourage any companies that are operating within California to avoid using time rounding with regards to breaks. And likely that means you want to reconsider whether you're using time rounding altogether. One of the advantages of time rounding that you get is that your numbers are all nice and round. It comes from the time rounding. But if your breaks are not rounded, then it kind of decreases some of the round numbers of some of the other ones. And so unless you can find a way to for sure make sure that you never have any documented cases of a break lasting less than 30 minutes, then you would want to be careful about that time rounding. Okay, I'll hand it back over to Derek real quick, and we're kind of at a good midpoint from this.
Yeah, so just to give people some context as far as what we're talking about here and the way to manage breaks. A question that we often get at trade shows and when people come in on our website, and people are frequently downloading our app and creating accounts, and when they'll meet with our account executives, frequently people will ask if our software does anything with breaks for California. And some of the feedback that we hear from clients is that they're using a really basic timekeeping software, and so they're still having their employees carry around a paper time card to separately document breaks. And so the purpose of this slide is ultimately to speak to that, where we've got people who are saying, hey, can I use software? Is it realistic to think that I can use software to manage breaks? Or do I need to use paper because software can't do this? Or am I in a situation where I have to do both? If I want to use an app or a software, do I still have to carry paper as well? And so we wanted to speak specifically to that because that's such a frequent question, especially for so many of our California clients and prospects. And so wanted to be able to pull up software and show you guys, if you are considering a software, these are things that you need to look for that the software absolutely has to have if it's going to solve your problem.
Yeah, so I'll speak to that a little bit more as well. So some of the principles here are going to be just general. If you're looking for software, this is what you want to look for. And I'm going to show some examples from BusyBusy of things that do those things. But to kind of just set the stage, one thing that you should be looking for with regards to software for the purposes of California break collection is that within software, there's a lot of different ways to enter the data. And for us, we have employees can track their own time, clocking in and clocking out. Supervisors can clock in employees and clock them out. You can have office admins adjusting time. You can have a kiosk mode where you have a lot of people using the same kiosk device. And all of those different places are opportunities where you might need to capture the break requirements. And so I would first recommend a software approach that has a lot of flexibility, because construction in particular has a lot of different ways that time can be captured. But also that each one of those ways that does work also has taken into consideration liability protection with regards to California breaks. So this is a couple screenshots of our product in action as far as an employee being able to clock in, and then there's a clock out button. They can take a break where they can have a timed break, and then the supervisors can also do those things for the employees. When you have California breaks enabled within our system, we will, whenever an employee clocks out, ask them the question of, did you follow California break policy? And with this question, we provide them some information. And this is something that I think just generally you want to be aware of, like if you're doing paper time cards or something, oftentimes you'll be capturing, did you get your breaks on a piece of paper? But you might not have access to some of the information about what it is you're actually agreeing to. What is these break requirements? And so from this screen that every employee would have access to, there's a link they can tap here, California break laws. And it explains the kind of timeframes that they need for those breaks. And it also has links to the .gov, the California.gov links that further explains the breaks. And that's important because you're capturing an employee saying they followed something, they would like to know what they're agreeing to. And so you have access to that right there. And so I would look for software that presents that to the information to the employee. And also that's one of the problems with paper is you also then need to make that paper available to all the different places so that an employee could know what they're agreeing to. The other thing we show them is how many, with their meal breaks, what their expected value is based off of their total for the day. So based on how long they've been working, we're giving them, these are your expected total values based off of these. And there are ways that you could waive those. Like if you've only worked 5.5 hours and you can waive those, then you could say you followed your break, you followed California break policy and explain that you waived those. And when you say yes or no, you have the chance to leave a comment as far as following the policy or not as the employee. The other thing we allow is for the employee to add a break themselves. And when they add this break, they come to this next screen, and we default the start and end times and the duration, but they can change these and say when the break actually occurred. And this again is important because it's the employee describing when they took that break and that they followed the California break policy. So these are examples of an employee doing this sign off. This same sign off experience is also available on the kiosk. And it's also something you can do when you're using a supervisor's device. A supervisor can have an employee do their daily break sign off on their device, and they just provide a signature so that they know it's them. And that's something you'd also want to kind of make sure that you are seeing in the software, is that if a supervisor can go in and just create all of these answers for employees, that's a problem. So you want, when the supervisor does make those changes to the time, that there's an employee sign off required as part of capturing that documentation. One other kind of thing that I've seen with software in this solving this problem, which is maybe different from paper or some of the other software solutions, is that our data capture for this data is like 100% because it's a requirement. So to clock out, you have to provide your daily sign off. And with paper, sometimes you'd have the hours, but you wouldn't have the break sign off, or you'd have some of the documentation, but not the other documentation. The software can help you connect those and make them requirements, which means you can go from having like some data collection or 80% or 90%, or depending how good of a company you have, maybe it's really high, but this can make it 100%, where every employee that clocks out, that question's answered. You've got that documentation, you've got the start and end times of the breaks, and you've got the whether they followed the policy. That's something else that you just want to be aware of. Another thing you should be looking for is visibility. So when someone says they didn't take a break, there's different people throughout the company you might want to be aware of that. And you can configure these settings to show to raise awareness of the problems to different employees. So on this screen right here, we have a supervisor report in the field where they can see that Kyle Washington had a break issue. There was a problem with their brakes. They weren't able to take the brakes, or they said they didn't follow the policy, or whatever the issue. They can investigate further by drilling into Kyle Washington. They also have a view where they can see every employee's total expected brakes and their actual brakes, and whether they follow the brake policy. And if they haven't answered yet for the day, it'll show like they're still clocked in. They haven't answered. We also have a notification so that people that have permission to access the employee's daily sign-offs can choose to get alerts whenever there's a problem. And so you get a push notification right away and know, oh, that someone didn't get their brakes, I better deal with that or investigate further. This is important so you don't have a long period of time elapse while there's a brake problem, or you might have a brake problem for a whole week or for many days, and this helps provide that visibility early in the process. You want that. You definitely want to know about the problems if you're recording the problems. On the website, you also have office admins that need to kind of understand what's happening in the field and be able to be alerted when there's problems. And they can also set their phone to send push notifications. But from their web dashboard, they can customize and choose to have different things alerted to them here on the dashboard. And they can configure this and customize it to be how they want it to be. But this lets you not have to look through all of the data every day to say, like, okay, I'm going to look through all of these responses, and if there's any no's or yeses, I'll know. This surfaces the problem. So you're managing more by exception rather than going through every single submission. And so this is something you'd also want, is you don't want to have to rely on yourself as an office admin or whatever to go through and check everything. You want it to be told to you when there's a problem. This is another report that, again, also shows like every employee, what their policy response was for the day, what their expected total was for the day, and what their actual break total was for the day. Is a break report. From here, you can add missing breaks, or you can add breaks for multiple people. If you want to add breaks for the whole crew while they're all clocked in, you can do that. And there's lots of different functionality there as well. This last one kind of shows another view where you can see issues that are flagged. Break compliance, this one's flagged. And you can see it in the context of your other compliance questions I mentioned earlier. So if you had injury protection or time accuracy protection, and you also have break compliance, you can see any one of these as flagged responses from the customers that, or from the employees that are out on the job site. And I guess a couple other things just to kind of generally be looking for with software. I would avoid, like I mentioned earlier, the auto deduction. As a project manager for this, we get feature requests of customers that are like, no, you need to make it so it just takes the time from the employees. And we've looked into that, and it's just not something we feel comfortable with doing and adding that to our product, where it opens that liability of employees not knowing that those breaks are being taken from them. And if they do know about it, then it's hard to show that they knew about it because they weren't participating in those breaks. And so, like I said, we do have the support for it to be really easy, and we want to make it easier, and we're always looking at how we can improve that process. But we're not big on auto deducting breaks, and until we find a way to do that in a legal, safe way, we won't be adding it to the product. Okay, I think that's kind of a quick demo of the
I can jump in, ask a couple more questions. Also just wanted to reemphasize a couple things that were said on here that I think are really critical. It's interesting, we have the opportunity on the sales side of BusyBusy to talk to so many clients, prospective clients, and people who become clients. And we have a massive user base in California. And one of the things that I'm constantly reemphasizing with my account executives who meet with companies is this is a big deal for people. I think California breaks is something that I'm not sure how many companies totally understand the liability that they carry with this. And so that's why we wanted to do this webinar. Again, we're not attorneys, and we are definitely encouraging people to meet with their attorneys and figure out exactly where they're at, make sure that they are compliant. But we're hopeful that this is really helpful because we built a software to be able to help businesses reduce their liability and increase their profitability. And so this is a big deal to us. And when we get clients in front of us who, when they're California clients and they say that they're not really worried about breaks, it's definitely something where I'm constantly instructing our sales people when they interface with prospective clients and current clients to really emphasize the importance of this, because there's more liability being carried than a lot of people realize. So wanted to point that out, want to make sure that from a high level, just bullet points. The rounding thing I think is a really big deal. Understanding that if you are using rounding, do not use rounding with breaks that's rounding up, because that obviously opens up a major liability. Not auto deducting, and auto deductions happen all of the time when we talk to people, whether it's paper, and because they're just gathering paper, they're just gathering time, and then they'll process payroll and just add the breaks in there, or whether it's a software where it is doing the auto deduction, or the other example is they use a really poor timekeeping product that doesn't have a deduction, and so they're just gathering time in a software and then they're doing an auto deduction. But definitely avoid auto deductions, avoid when you're rounding up, and be really, really aware that your policies state that your employees are not allowed to work during their break periods. And then, like Charles said, it's like, hey, if people are working during their break period and you're aware of it, don't turn a blind eye to it, because it is something that would be discussed in court. So hopefully those bullet points help as well. A couple other questions for you, Charles. We had a question from someone that wanted to clarify what the 6 hours looks like. So they said if they work 6 hours and waive their 30-minute meal break, and it is agreed by the employee and the employer, a signed waiver should be signed, correct? And then she added, we are not required to pay the additional hour, we just pay them the 6 hours.
Correct. Yeah, that is correct. And assuming you've got that documented, which, like in the software context, you would have them say, yes, I followed policy when they were at like 5.5, and the software would be saying, hey, you should have a 30-minute break here. And then in the comments, they could leave, waiving that break. I'm good. And then they're just paid as normal. Yep. There's nothing to like have to pay them an extra hour for that.
Okay, great. Another question is clarification of meal breaks. Do they have to start before, big emphasis, caps on before the 5th hour of work starts, or before the 10th for the second meal break?
Yeah. So no, they don't. Once they get to that 5-hour mark, they can start their meal break, but they don't have to start it before. So It's after.
So is it any time between like the 5th and 6th hour, or how close does it have to be there?
Yeah, I mean, it's obviously always going to be a bit of a gray area there, in terms of like when it comes down to it, what were employees told, like you can't take your lunch break until this time. Like if you look at the rules, it's that once they've been working 5 hours, they need to be given that meal break. If there was an agreement, like I said, where they could waive it, or for some of them, like on the rest breaks, you can do a rest break where you can put it on a different part of the shift, as long as that's okay with the employee and whether it's part of like the actual functioning of work. But I would say like you want to be careful about saying like, oh, you can't take that break until the 6th hour. If you kind of left it more to the employee, okay, you can start taking your break now. You've made that break available to them, and then you don't want to be flexible with making sure they still get their full break if they aren't starting it right at that exact time.
Yeah, and there are a couple other questions that came in around that, just further clarifying that if they start at 6 a.m., then they're okay to start their meal break at 11, not at 10:59. Again, that's where the rule is 5 hours, and we definitely want to say, hey, you might want to just check with an attorney to understand exactly what they're recommending that you do, whether it be 10:59 or 11:01. But the rule is 5 hours, and that's traditionally what people have followed. And so if they're starting at 6 a.m., then the expectation for that meal break would be at 11 a.m. Another question for you, and this one also sounds like it should probably be deferred to an attorney, but I'll ask it just in case you have some insight, Charles, there as we refer that, is on bidding day, we require office employees to skip lunch sometimes to work through their lunch hour as we put a bid together, but we provide a very nice lunch of their choosing. Does this suffice, or is it better to allow them to leave 1 hour early?
Yeah, I actually think what they could have, as long as this was a paid lunch, that would qualify. If they weren't paying them and they were requiring them to be on site, then that would be a problem. As far as like offering them the lunch, that would also be fine. Like you can give employees lunch. If they wanted to bring their own lunch or something, they could, or if they wanted to do something else during the lunch, they could. But as an employer, you are required, or you are allowed to require them to be on site, but not without paying them. They have to be paid. And then if you're also expecting them to for sure be working during that lunch, that's gonna maybe raise some flags as far as being designated as that on-duty lunch, which would mean that hour of premium pay. So that would be the way you would actually pay for that. And like, yeah, we know that's the rule, where we pay 1 hour for those days for the employee to be working during that lunch, which the lunch is only 30 minutes, and then you're paying them for that extra hour. So it's kind of like you're getting paid even more from the employee side, but that would be the way that you'd probably resolve that. And again, yeah, for sure, refer to an attorney if you have a question beyond that.
Okay, well, want to apologize if there's a handful of questions, actually quite a few we didn't get to, but we want to be respectful of time, understand that we've taken nearly an hour of time at this point. Really appreciate everybody attending. Very much appreciate all of the information that Charles shared. If any of you have additional questions, or you did submit questions that we didn't get to, feel free to email those over, and we can review those, email back our thoughts, and then again, definitely would refer any questions to continue to just talk to an attorney, make sure that you're taken care of, and that you're doing everything you can to protect your business as you're putting forth all that effort, not to just give it away because of a silly lawsuit and liability you carry that you didn't know about.
Yeah, Derek, I would also just add, if you have questions that are like about BusyBusy and how we solve some of the problems, or you have suggestions, or you want something to be done differently, within the product, we have like that suggest a feature. And when you submit those come to me and my team, and we see those. And so if you have any sort of like, well, I want this additional feature to the way I do with brakes, you know, send them in. We take those feedbacks, and we're always adding features to the brakes.
So yeah, interestingly enough, there is someone who attended this webinar who is a current customer of ours, and they've been a client for a long time because she specifically mentioned that she had requested California brakes years ago and was excited to see it come out. And she actually, again, they've been using the product a long time. She asked a question about rounding, Charles, where she asked if they use the rounding in the product as employee favorable, so it's always rounding in the employee's favor, how that would affect the California brakes.
Yeah, it's a great question. That ruling in 2021 is going to change the way we're going to present some of the brake totals in rounded cases. And once we make those adjustments, that would be something that would be recommended or recommendable, where that time rounding is like super employee favorable. But as it current stands, like just having read through that court information with like time rounding is not allowed, and just really strict language where even though the particulars likely make that acceptable, I would still caution against it until either we get further clarification from the courts, or until we add some more language within the product to further protect against that.
Yeah, cool. Well, Charles mentioned the software, talked about how you can inside our software do feature requests. Also, just from a standpoint of those of you who are on here who don't have the software yet, BusyBusy.com, you can create your own account there and you can take a look at it. You can also just go on the website and ask for more information. And again, appreciate everybody attending, and please let us know if there's anything else that you need.
Thanks, everyone.